Welcome back to Beyond Red and Blues Crucial Case Law Series. This week we
have Terry versus Ohio, a case decided in 1968. Facts of the case: a plainclothes officer observed two men peer into a store window multiple times before going to a street corner where they would confer. Eventually, a third man came and met them at the corner before the pattern repeated itself. This went on for anywhere from 10 plus minutes, where they would go to the store, peer into the window, and return to that corner to confer. The officer eventually approached and identified himself as a police officer. He patted down Terry and located a pistol in his trench coat. Then he patted down the second man, Chilton, and also located a pistol. The third man was patted down, but did not have a weapon on his person. Although he didn't have a weapon, all three of them were arrested, but only two were charged with carrying a concealed weapon. The initial courts approved the investigatory stop and frisk, and the two were found guilty on weapons charges. It got appealed several times and eventually went up to the Supreme Court. And the Supreme Court ruled 8-1 on several different things. First, they established grounds for what is an investigatory stop. This essentially is a brief detention for police to question upon suspicion that someone may be connected to a crime. So this established what we now know as reasonable suspicion. And reasonable suspicion is, in brief, articulable facts that lead an officer to believe that a crime has occurred, will occur, or is occurring, and that that person is part of that criminal activity. The second thing that it established is a frisk. And the frisk is basically an pat down of someone's outer clothing for weapons specifically. It is a minor search that is not a fishing expedition, essentially, and it established that two requirements must be met. First, they must be able to articulate that the person is detained, which requires that reasonable suspicion, and that the person is armed and presently dangerous. And although the courts have not openly defined what armed and dangerous means, they essentially allowed officers to rely on specific and articulable facts that would lead to a rational inference. And some of these examples include things such as bulges in your clothing, so a bulge in the waistband or other places where weapons could be consistently concealed could be articulated as somebody being armed. Furtive movements, again, reaching in these common places or inside of a vehicle in common places where weapons could be concealed. Having prior knowledge of somebody being armed and or dangerous, this can lead to that articulation as well. The nature of a suspected crime, and in this case of Terry, the three were suspected of armed robbery. And so there was articulation that based on the nature of the suspected crime, that the person would likely carry a firearm to carry out said crime that he was being detained for. The location and timing, in these scenarios, it could be such as an isolated area, it could be a late time of night, a high crime area, or an area known for recent insert crime here. Those can all lead to some sort of articulation as well. And lastly, someone's behavior. Somebody is overly nervous and clenching their pockets could indicate that they're trying to conceal or maintain something in a certain way. So in short, Terry versus Ohio establishes those three major key things for us. What is an investigatory stop, a detention, and when is it lawful to do a stop and frisk, and what are those parameters of the frisk itself?
Okay, so we'll leave you guys with the challenge question. I'll give you a quick scenario. An officer sees someone walking alone at night wearing a hoodie and looking around nervously. The officer stops the person just because of the hoodie. No other suspicious behavior is observed. Is this legal under Terry versus Ohio? And I'll leave the answer in the description.
All right, like always, if you guys have any other case laws that you'd like us to go into, make sure you leave it down below. See you guys next week.